So you may have seen that Prince Harry has settled his claim against one of the newspapers, or rather the newspaper's thrown the towel in and agreed to pay him some damages and some costs. Now, how can I pad that out a little bit? The first thing to remember about settlements is you can read nothing into them. People settle for all sorts of reasons that have no bearing on the merits of the case. Although in this particular instance, the newspaper have obviously taken a pragmatic view and gone, well, he's got home on some of these issues, some of his claims, about half of them. And what they're clearly concerned about is, well, if this goes on, even with that success rate, the danger is, applying the loser pays winner's cost rule, the court might say, well, notwithstanding you didn't get home on everything, you have substantially won. You brought a load of claims and you've been successful on some of them. So you should get your costs. Now, those costs will be discounted to an extent by how much time they actually spent on each of the issues. But in these particular cases, a lot of the time was what we call common issues. In other words, what was there hacking in the first place? Regardless of, each individual particular incident, or they couldn't sort of prove that one particular piece of information came from hacking. So newspapers take the pragmatic view, because the thing to remember is, with costs, even if you win, you never get all your costs, because they go for what we call assessment, and you're lucky to recover sort of 60-70% of your costs, so you can be left with huge shortfalls. But in this particular case, the newspapers are facing claims from like 100 people. So they've probably done the spreadsheets and gone, you know what, it's just not worth it anymore. So what have they done? Well, they've paid him £400,000. But that's just on what we call account. So there is more to pay. So what they've probably said is, here's a sum of money for your damages, and we'll also pay towards your costs. But if they can't agree the cost, that's it, they'll go off for that assessment. People try to avoid that because the thing with what we call detailed assessment is, it's like a hearing where you go line by line through every single expense. It's for the receiving party, generally, to prove that everything they have spent is reasonably and necessarily incurred, and that the overall costs are proportionate to the litigation as a whole. Sometimes courts can make an order where somebody's to pay costs on an indemnity basis. The same rules apply, you have to show that it's reasonable and necessary. But in that case, it's for the paying party to prove that things weren't reasonable and necessary. The starting assumption is, yeah, all these costs are legit. Also, there's no element of proportionality there. So, you can have a £100 claim and rack up £10,000 costs. So in this particular case, what have they done? Well, the fact they've offered 400,000, when things go for detailed assessment, usually there is a payment on account. You say, well, even if we get knocked back sort of 30%, we're going to recover at least 70% of our costs. So pay that now, and we'll argue about the rest later. So what they've probably done is, by paying £400,000, they'll probably try and agree the balance between themselves rather than it go off for assessment. But the fact they've done 400,000, usually a payment on account is about 70, sort of 80%. So it looks like they've budgeted for £500,000 for Harry. So yeah, he'll see this very much as a victory, one would imagine, and I suppose quite rightly so. I'll keep monitoring this, because I had a little look as to how many cases Harry was involved in, and there's 3 other cases. There's 2 other phone hacking cases, and then there's also his claim against the Home Office about the providing the security. That's the judicial review. So, we'll obviously bring these all to you. Right, as you can probably see, I am in Middle Temple today. I'm up to do yet more advocacy training. Actually, they're going to try and teach me to teach people to teach advocacy. That's the theory anyway. But this is Fountain Court, because of the fountain. That's in Martin Chuzzlewit, if you like Charles Dickens. And that's Middle Temple Hall, where I'll be working today, one of many happy hours. Because I'm old enough that when I went to bar school, because there was only the one bar school then, realistically all you had to do was eat 18 dinners, and I used to eat them in there. I'll tell you all about that. If there's any interest in how you become a barrister and all the obscure little rules and rituals, let me know, and I'll take you through them. But the key thing we do at this inn, as I've said before, is it's all very pretty here, but we want to stay relevant. And the way we stay relevant is to do things like offer advocacy training. We train up the next generation of barristers. And we do it here in lots of places actually. I've been in this week, this month, been in Bristol, York, a few other places doing it. It's quite exciting. Sometimes I get to go abroad, which is very, very exciting because you get to compare and contrast the different legal systems and the different legal cultures. But like I said, I'll be up here again in a fortnight, so maybe if you let me know in the comments if you want me to sort of film it inside the hall or all around here, because it is very pretty. Anyway, as always, hope you found that vaguely useful, vaguely interesting. Vaguely padded out because it's not much of a story. If you did, please consider liking, sharing, subscribing and all the usual YouTubey things.